Hi, this is Alex from Lawyer Up Burger Law in Marquette, and I am here to post about a success we had this week. It is a little bit in the weeds in terms of a legal issue, and it's not an impaired driving case, but I thought it was interesting enough to post about nonetheless. So it was a case where my client was driving. He was pulled over, and he ended up consenting to a search of his person, which is not uncommon. The officers found a baggie which contained methamphetamine in his pocket, and his initial and continuous response was that his daughter had picked it up off the ground. He thought it was trash. He put it in his pocket and forgot about it. But he was charged nonetheless with a 10-year felony, meaning that he could spend up to 10 years in prison if convicted of it for possessing methamphetamine. So we went through the whole trial preparation process. I was pretty sure we were going to go to trial, and the prosecution would have to prove beyond a reasonable doubt that he knowingly possessed methamphetamine. Ultimately, the prosecution made a pretty reasonable offer. If he accepted a conviction, they would do sentencing under what's called 7411, and that's a reference to MCL 333.7411. What it is, it's a first offender drug statute. So even if it's a felony, if you find yourself guilty of a possession of a controlled substance offense and you've never been in any trouble before, they can defer adjudication, meaning you don't actually get a conviction. And then you're on probation for a little bit, and then the case is dismissed. You don't have a conviction. You don't have a criminal history for most purposes. So it's a really good deal. And we were able to work it out where my client was able to accept that deal under the facts of the case. And so we, did the whole thing, and then we had a sentencing scheduled this week. And in any felony case in Michigan, the Michigan Department of Corrections does what's called a pre-sentence investigation interview, where they talk with the defendant before sentencing to try to get a full picture of that person. They run the sentencing guidelines, which gives a sense of how the criminal history and the particulars of this person and the crime go into a guideline range. So it's all pretty technical, complicated. These pre-sentence investigation reports are usually like in excess of 20 pages, sometimes up to 50. So it's a pretty substantial thing that they do to prepare for sentencing. In this case, the 7411, the deferred adjudication, it says that they shall be placed on probation. So I just told my client, let's show up and see how long the judge puts you on probation and how long the MDOC recommends for probation. So we went through that process, and then we got the pre-sentence investigation report back, and it recommended the 7411 deferred adjudication, but then it also recommended 90 days in jail, which would ruin my client if he were to be sentenced to 90 days in jail. So we clocked into gear, did some research. I talked to a number of colleagues. I talked to people at the MDOC. And apparently a couple years ago, there was a statute that changed the probation statutes. And it essentially said that a term of imprisonment in the county jail is an appropriate and okay condition of probation. So there is a statute that seems to indicate you can be sentenced to probation only, but have to spend time in jail. So I, along with Christina, prepared a brief to explain why that statute should still disallow jail sentence in a 7411. And we went into court well prepared. I made my argument, and the judge had prepared, I think it was like a 15 to 20 minute explanation of his position. And his position was that jail was permissible under a 7411, but nonetheless, my advocacy got him to agree to no jail time, even though the MDOC was recommending it. So it was a great success for my client. It's exactly what he bargained for. The risk of losing a trial was just too great not to accept a complete lock-in of no criminal history. So it was a good success. The judge spent a lot of time thinking about the case, but ultimately we prevailed. But there are two takeaways I think you should take from this. Number one, Never consent to a search of your person. You never know what you're going to have in your pocket. It can be completely innocent, and it can lead to something like this where you're worried you're going to spend time in jail because of that mistake that you allowed them to search your person. And then secondly, 7411 is something that's very prominent. Anybody who gets in trouble for a drug case, just know the judge convinced me that I think legally jail time is absolutely on the table if you take a deferred adjudication under 333.7411, otherwise called a 7411. Thanks.